Hello everybody, welcome back to the channel. This is a continuation on American Jurisprudence, Volume 13 on Business Trust. Today will be Part 3 on Shares and Certificates, starting with Section 22. Hopefully you guys enjoyed and subscribed my other videos, so this way I could continue making these videos. I do plan on doing this whole 164 pages, so we'll see how long that takes. 40 minutes I think has been a good number. So Section 22. The proportional equitable ownership interest of each sesquique trust in a business trust is usually evidenced by a certificate known as a share, stock share, certificate, or receipt. The certificate is a muniment of title and evidence of the ownership of stock, and it has been said that such certificates are not chattels but are evidence of intangible rights which have some of the characteristic qualities of chattels. The courts have taken somewhat different views of the nature of shareholder rights in the trust estate, depending to some extent upon the purpose of the determination. Thus, the interest in the shareholder in the business trust has been said to constitute personality, which is personal property, and not real estate, although the trust estate consists largely of real property. So that's a good case that I would recommend reading, right? Number 3. Right? Malroy versus Russell, an Iowa case, holding that the wife of the deceased sesquique trust cannot claim dowry in the land over the trust. They got a few of them where they're considered personal property. How they write that up in their trust instrument, and how much powers ultimately the beneficiary exerted will determine that. And notwithstanding the frequent statement that shareholders have an equitable interest in the trust property, however, for purposes of taxation, it has been held that shares in a Massachusetts trust partake of the nature of the trust property and are real or personal property accordingly to the property of the trust is actually or under the principle of equitable conversion. So that's number 5, and there's a good court case, Bartlett versus Gill, the federal case. The certificate holders are the ultimate proprietors of the property of the trust, and their rights constitute not chooses in action, but of substantial property right. This case involved inheritance tax on shares. The nature of the interest of a shareholder in a Massachusetts trust, the entire estate of which consists of real property, was held to be an equitable interest in land, for the purpose of legacy and inheritance tax. This involving an organization that was a true trust and not a partnership. And a certificate of shares in a true business trust have been held to not be a security within the meaning of a taxing statute, but a muniment of title to an equitable interest in real estate constituting the trust res. So what they mean by this is that you're not making income as no. You're not making income based on some pro rata rate that the shares are valued at how they are on the stock exchange. Where you could go on the stock exchange, buy a $50 share, okay, well that has a value onto it. And then you're receiving some type of interest based off some value that you have with it. Where in this case, your value is based on whatever the trustees ultimately say it is, what that share is worth, and that's when you write down in your documents that it has no par value, and it ultimately has value only when the trustees give it value. In the absence of statutory provision to the contrary, it would appear that shares in the business trust are not subject to execution or attachment for debt to the shareholder, and that's a spendthrift provision right there. The shares of a business trust are sometimes listed and dealt in on stock exchanges, and this is true. Like, actually, like unincorporated association, right? Under that book, you'll find, man, the New York Stock Exchange is one of these types of organizations itself. Not to mention organizations, like Walmart and whatever else, right? That are traded on the stock exchange. But nonetheless, it's an unincorporated entity that is making their shares public. Provisions for trust instrument for trust shares. Footnotes, Schuming. For footnotes, these certificates would resemble certificates of shares of stock in the corporation and are issued and transferred in a like manner, entitle the holders to share ratably in the income of the property and upon termination of the trust in the proceeds. And that's it. Whenever the trustees declare it, they get a chop, and at the end, that's it. That's the only rights they got. That's the only rights they should have. Transferable certificates of shares in a business trust are equitable chooses in action, bearing a close resemblance to certificates of stock in a corporation. And that's this case. Even though up here they said different. Where they have it out. Chooses of action. If I lost it, is it down here? Yeah, see, right here, like this court case, in terms of, it's always about context, right? So in this, the context of inheritance tax, these shares are does not constitute chooses of action, but substantial property right. But up here, with this case, right, are equitable chooses in action bearing close resemblance to certificates of stock, right, which are securities. So it's like, what's the context in this case that made it so? Designation of shareholder certificates as unit certificates does not change their real character, but since they are essentially certificates of stock in an association in spite of that designation. There's these. Parker Mona, holding such shares to be personal property and accordingly to convey no interest in an oil lease, this being regarded as real property. I know there's a percentage, like if your trust consists of like 80% where the income or whatever is derived from real property, then the shares itself are real property or something like that. I forgot how it goes. So always it's important to create other trusts and for similar purposes and stuff like that. You just isolate the property instead. You just got to make sure whatever trust that you're creating that holds property for another purpose, that it makes some type of income for itself. Once you separate property from your main trust, and your main trust is the only place where you're making income, well, you have to make sure that the new trust can make income on its own also to pay for itself. Like in this case, they said shareholders are equitable tenants in common. The interests of shareholders in the business trust have been held not to be attachable in an action at law, since they can only be reached through proceedings of equity, which is true. Section 23, classes of shares, participation agreements, and so forth. As in the case of corporations, business trusts may be empowered to issue preferred or as well as common stock, to issue more than one class of either type, and to issue no par shares. So if you guys read the the Standard Oil Trust, right? Rockefeller stuff from that book, Unincorporated Associations. Um, Man, you'll find that they had like 5 or 6 different classifications of shares. People receiving different property rights, in essence, for each class, depending on what their investments are or just as is because the grantor chose to benefit them. The character and terms of such shares are usually prescribed by the trust instrument, and their form is similar to that of shares of corporations. Business trusts organized for the purpose of producing oil sometimes issue, in addition to the ordinary trust shares, participating agreements entitling the holders to a certain share of the oil produced. So that means that they're not getting income, they're getting a chop of the product. The distinction between such participation agreements and ordinary certificates of beneficial interest will be observed by the courts. And this is probably because they make some type of partnership too. Who knows? You're involving some other investor for the purposes of creating income to coming together with some other agreement. So who knows? Outside of reading what they're referencing, right? Like footnote 12. Schiffman versus Richfield Oil, holding that a reference to such a participation agreement by the owner thereof in a pleading as certificates and as beneficial interest in said trust will not preclude him from asserting that the agreements are not certificates of beneficial interest. I don't really understand that. Holding that a reference to such participation agreements by the owner thereof in a pleading as certificates and as beneficial interest in said trust will not preclude from asserting that the agreements are not certificates. I don't know. I gotta read that case. I'm not understanding this part right here. Will not preclude him. Will not stop him, prohibit him, or be prohibited from someone else. Because they're not the same. Participation is not the same as a shareholder. An agreement. You're introducing another agreement. Will it be called another share? Who knows? A different type of share. Trump instituted provision as to dividends on preferred shares. They give you a resource there. 3 American Jurisprudence legal forms. That case is going to bother me right there. Let's look this up. Let's take this whole thing. Oh, that's the wrong one. I'll read that later. Section 24, subscription or purchase. The trustees of a business trust are usually given the power to receive subscriptions to shares in the trust and to sell and issue some shares. It has been held that sales of certificate of shares in a business trust are not governed by the Uniform Sales Act, except the the statute of frauds embodied within. Statute of frauds is important because it just requires a written instrument for certain transactions, and it's almost always dealing with real property. So land, real estate, that's all it says. Write up a contract. Write it up. Can't be verbal. And in the jurisdiction regarding business trust as being in the nature of corporations, a sale of shares is not the equivalent of doing business within the intentment of a statute requiring foreign corporations to qualify in a certain manner before doing business within the state. Now, to understand this better, it is because of one concept. All it is it's an American under a contract that makes him a trustee. That classification of American with fundamental rights does not change. That means your right to egress and ingress into any state and to do business is 100% protected. That's why this statement exists. That's number what, 14 and 15? We'll do 15. And it gives you a case. I don't got that law review. Home Lumber Company versus Hopkins. It's a Kansas state case. But that's what that is. However, shares of a business trust have been held to be within the operation of a statute prescribing certain conditions for the sale of stock of any corporation, company, or association. And we learned that in the last section, in the last part 3. The trustees may maintain an action to recover the amount due on subscriptions to shares, or at least so much thereof as is necessary to enable the trustees to satisfy obligations incurred by them on the strength of the subscriptions. So they're just saying you got the power. You have the power to give your trustees the power to go collect money and bring suit and all that other stuff. And then they say, at the very least, enough necessary to enable the trustees to satisfy obligations in the strength of subscriptions. Would that mean you could write up, say if you have a promise to pay for a subscription, meaning that the person that is subscribing is making monthly payments, right? Because he's under a promise to pay for the full thing. Can you create a negotiable instrument or some type of instrument for you to do some obligation with the trust with that negotiable instrument which represents the debt that he owes? I want to say yes. So you could fulfill your obligation by using a promise to pay on his promise to pay on some debt. It's a contract. And in like manner, it has been held that a creditor of a business trust may maintain a suit in equity to require the trustees to collect and the subscribers to pay amounts due and unpaid on subscription agreements, under the theory that subscriptions to capital stock of the business trust are capital assets which, upon insolvency of the trust, constitute a trust fund for the payment of its debts. Such a suit will not be abated because the statute of limitations has run on subscribers' notes evidencing the unpaid portions of their... See what I'm saying? Such a suit will not be abated because the statute of limitations has run on subscribers' notes evidencing the unpaid portions of their subscriptions, since the action is founded on the subscribers' continuing obligation to pay their agreed portions of the capital of the trust rather than on the notes given as evidence of their obligations. And that's a concept. Those are things that you could use to create funds. Whether or not the trustees of a business trust have the right to repurchase its own shares depends upon the terms of the trust, such as repurchase for the purpose of cancellation has been held not to be improper. So that means you could recall your shares for whatever reason, but you have to compensate them. You can't take away what the trust was created for, basically. So whatever reason you have to recall the shares have to be in accordance with the trust and in favor of the beneficiaries. Also, it has been held that a subscriber for shares in a business trust may enforce an agreement made by the president and trustee of the trust that if the subscriber became dissatisfied, the trust would take back the stock and refund the purchase price. It's all dependent on you, the grantor, to write this in. However, the trustee of a business trust has been held not to be personally liable on a guarantee to a subscriber executed in the name of the trust contemporaneously with the purchase of shares, where the bylaws of the trust exempted the trustees and shareholders from personal liability on any engagement or contract made on behalf of the trust, which is exactly what you're supposed to do. But to understand, right, this portion, right, what they're allowing to do, you could also do this as a spendthrift portion, where you want to repurchase them because the beneficiary is trying to sell them to someone else. Right? In some states, you can't deny them that right to sell their personal property like that. Right? In some states, you can't because it's looked at differently in terms of the property laws. But in the states that you can't, you could require them to offer it to you first for a purchase price to try to match the sale or whatever of what they're getting. But it has to be a bona fide sale. So they actually have to have somebody making a bona fide offer to them, on paper or whatever evidence that you require or the law requires. Supplement, don't say nothing. Footnotes. Holding that the conveyance by the trustees of the land constituting the capital of the trust does not end their power to sell shares in the trust. Trust instrument provisions as to the sale and issuance of shares by the trustees, legal forms. And you got court cases. And they tell us right here, footnote 16, go see sections 80, 82 coming up. And that's going to be the blue sky laws. That's when, of course, that your shares are considered securities. When they are. Involving trust instrument containing stipulation against personal liability of the shareholders and trustees and providing for non-accessibility of the stock only to the extent that it was paid for. Section 25. Effect of fraud, misrepresentation, or violation of law. Upon the proper showing of fraud inducing his subscription, meaning you, the promoter of you selling the shares, a subscriber to shares in the business trust may rescind the subscription and recover the amount paid by him thereon, or he may maintain an action for damages. By electing to sue for damages, the subscriber precludes himself from thereafter rescinding the contract of subscription. The subscriber may, of course, waive any fraud inducing him to purchase the shares and may ratify the contract of subscription, but he cannot speculate upon the success of the venture by waiting until events disclose whether or not it will be to his interest to rescind. It has been held that a shareholder cannot withdraw his subscription after he has paid for his shares and permitted the use of the subscription as part of the capital of the trust, as against a creditor of the trust, even on the ground of fraud where the creditor is without notice of the fraud. And in the absence of fraud or misrepresentation, a subscriber cannot hold a promoter liable for the amount paid for shares in the trust merely because the project failed. I will read those court cases. A shareholder may maintain an action against the trust based on fraud and misrepresentation in inducing her to subscribe for the shares without any accounting or dissolution of the trust, stating that since the subscriber had permitted his stock contribution to be used by the trustees to carry on trust business, he would be held to have acquiescence to the fraud. One induced to purchase shares in a business trust which has violated the law by its failure to comply with the blue light clause may rescind the subscription and recover back the price set thereon. This is clear where the non-compliance with the statute renders the shares of the sale valid, thereof void. This is clear where the non-compliance with the statute renders the shares and the sale thereof void. So this is when you are entering the public to sell your shares, and then you do something, you're failing to comply with the statutes of the blue sky laws, and your subscribers don't know this, or they figure it out that you didn't. Dude, they could void the sale of those shares because you weren't in compliant with it. There's a couple court cases. Maybe they have it here. No, but I got a law review. I'm surprised they don't mention a law review here. Such a subscriber is not in peri delicto, and he is not to be precluded from asserting the invalidity of the sale of shares on the grounds of ratification or estoppel. The trust cannot recover on a note given for the purchase price of shares sold in violation of such a statute. Section 26. What amounts to fraud or misrepresentation? The sale of shares in the Massachusetts or business trust is not fraudulent per se, so as to entitle the subscriber to recover damages for fraud or deceit on the sole ground that the organization was a business trust and not a corporation. In the absence of a showing that there was misrepresentation in this respect, and that the misrepresentation that the shares were those of a corporation was material to the subscriber, but a false representation by a person selling shares in a business trust that the organization was a corporation organized under the laws of the state has been held to constitute such a material misrepresentation and would constitute a defense to an action on a note by one other than a holder in due course, where the shareholders in such a trust were not accorded the same immunity or liability as were stockholders in a corporation. Let's go down here. Let's see what they say. Footnotes. Stating that the question whether it was material to a plaintiff to have stock in a corporation instead of a business trust, so as to entitle him to recover on the ground of misrepresentations in this connection, is a question which is ordinary for the jury. See, and this is why they, in their statutes, right, both for corporations and for trust, right, on your DBAs, right, where they don't allow you, like an LLC, they don't allow you to put incorporated or corporation at the end of your name. And the same thing with trust. They don't allow you to do like specific government names. They can't stop you from incorporated or anything else, right? Because that's freedom of speech. Before a corporation, they can restrict their speech. So they restrict them to writing LLC or limited liability company or something to that effect. They'll have like 5 different terminologies that you could use, but you cannot use corporation or anything else, or even trust, right? You can't state opposite of what you are, but a trust can. A trust could. So it's like that aspect of it you have to be in line with. Don't make them believe you're a corporation if you are a corp. You just somehow, some way in your writing, it states it's just a name, and your true organization is a business trust. Otherwise, you get this misrepresentation. A provision of the Declaration of Trust to the effect that shareholders shall not have the right to call for a partition or division, a dissolution of the trust, or an accounting, is not on its face fraudulent so as to entitle subscribers for shares in the trust to a rescission of their subscription, nor is a provision authorizing the expenditure of 30% of sums collected by the trust as commissions for selling stock for promotion purposes. So this is expenditure. That's the cost of whoever is putting in the work too. That includes if that it's you, right? But what I'm saying is they're stating a concept here, right? Just because you purchase something and that are just not be given the benefit of something like a normal beneficiary that you purchased a share doesn't entitle you to state that this is in violation or misrepresentation or anything like that. This is powers that the grantor has the right to do. And that right is that you cannot call for a partition or division or dissolution or even an accounting. You can't call for it, but you have a right to one. So that means that I have to give you one on my convenience, whatever it is, reasonable time periods. That's literally it. You have a right to an accounting, but you don't have a right to call for an accounting as a beneficiary, regardless if you purchased the share or not. But in this case, in this section, they're talking about for subscribers specifically, why you don't have these powers. But this right here is, 30%. You promoted the business to get people to come and invest. And the breach of a promise made by promoters and trustees to a subscriber for shares that the trust would buy printed matter amounting to a certain sum from the subscriber does not entitle the latter to a rescission of his subscription contract in an action based on fraud and misrepresentation, and not for damages not for damages for breach of the contract as to the printed matter. Where the promoters and trustees of a business trust have grossly and fraudulently exaggerated the value of a lease transferred to the trust, shareholders may maintain an action against such persons for the collection of the transfer, the rescission of their subscription contracts, and the recovery of the price paid for their shares. But the improper appropriation by trustees of property of the trust is not a ground for the rescission of a prior sale of stock to subscribers. One who is induced to purchase shares in a business trust by false representations that the organization has complied with the Blue Sky Law may recover back the amount paid for the share. So this is so the other one was if you're acting like a corporation, right? And comply or did not comply with a trust that you did not comply with the Blue Sky, and here they're saying that if you did, or you're saying false representations that you comply with it. That's footnote 1. I wonder that. See, that's still they. I don't know why they don't have the law review here. The other book did, but they give the same court case. Section 27, transfer or pledge, and they actually give us an annotation for that. So footnote is as to bequest or inheritance, right? So they tell you go look at section 29, which is coming up to. One of the distinctive features of the business trust as compared to an ordinary trust or a partnership is the transferability of its shares. It is in no way illegal to provide for transferable shares, and instruments declaring business trusts usually contain such a provision. Statutes prohibiting or restricting the transfer of interest in trust have been held not to apply to business trust. It is competent to provide in the trust instrument that the shares of a business trust must be offered to the trustees before transferring before being transferred to outsiders. It says it is competent to provide in the trust instrument that the shares of a business trust must be offered to the trustees before being transferred to outsiders. That's offered the sale to the trustees if they wish to buy it. A provision requiring that any shareholder or his personal representatives desiring to sell and transfer his shares in the trust should file with the trustees a bona fide offer from the proposed purchaser, and giving the trustees the right to purchase the shares at the price offered within a period of 10 days is valid. Where this is done and the trustees do not elect to purchase the shares, they may be compelled to transfer the shares to the offerer on their books. And that's the whole the whole thing. To protect your trust is you're getting the choice to buy them back, or you might be compelled to have an outsider be an owner, like somebody's creditor. If the trustees fail to make a periodic valuation of the shares of the trust as required by the trust instrument as a basis for the acquisition of the shares of a member who dies or withdraws, the court may determine the true value of the shares. So, if the trustees fail to make periodic valuation of the shares of the trust as required by the trust instrument, so this is what? If the trust instrument is required to make a valuation of the assets as a basis for the acquisition of the shares of a member who dies or withdraws, the court may determine the value. So this will be for like some purpose that for the guy who died, right? The court is trying to collect some tax because of some estate tax, inheritance tax, or something, some transfer of property from his death. Yeah, what case is that? Number 9. Dooley versus Redden. See, a lot of these cases I'm not familiar with because, again, these are new. This is volume 200. Volume 256. Even 152, that's relatively high. Meaning it's like in the 1970s or 80s and something like that, maybe more recent. Shares in a business trust may be pledged by the owner thereof, and it has been held that they may be pledged without complying with a provision of a trust instrument requiring a transfer on the records of the trust and the issuance of a certificate where there has been a transfer of the shares. And this is because this going to be the state law, right? Shares in a business trust may be pledged by the owner, meaning the beneficiary, right? And they give you a court case, and they don't give nothing with it. And it has been held that they may be pledged without complying. Now, why would this be a thing? Why wouldn't the beneficiaries be required to comply with a provision in the trust? Is because that provision would be illegal to public policy. For whatever rights that he has under the state, right? This fundamental rights being upheld in the state and on property laws doesn't allow the trust to stop him from selling his personal property. That is a fundamental right that he has in that state. It has been held that they may be pledged without complying with a provision of the trust instrument requiring a transfer on the records of a trust and the issuance of a new certificate where there has been a transfer of shares. That's footnote 11. Supra. So they quote another case in which the pledge was attacked as fraudulent by creditors of a shareholder. Section 28, effectuation of transfer. What makes it legit, right? Instruments creating business trusts usually prescribe the manner in which the transfer or assignment of shares therein is to be effectuated. See, they even here, the next sentence is, the instruments create the manner. This is the bylaw on how a transfer should be assigned, or what a transfer or assigned. Assignment's worse, right? Because you don't really want that. But transfer means, complete transfer. Assignment means you're letting them borrow it for a while, right? Or up here, this specific state, it doesn't matter if you write it or not. And that was Illinois. I got to read that case because I don't know this case. 300 volume? I don't know that case. Matter of fact, before I forget, probably read that first because it's actually more important in terms of where I am at in regards to trust law. Where these up here are, stuff for partnerships, corporations, and so forth. It says these provisions are binding upon purchasers of shares as well upon other persons. Thus, it has been held that the trustees of a business trust may refrain from transferring certificates on the books of the trust until the procedure prescribed for transfer has been followed, and may withhold payment of dividends to the transferees until transfer on the books can be made. As between the parties to the transfer of shares unperfected on the books of the trust, however, the transfer is good, and actual knowledge thereof will charge the trustees with liability for dividends paid to the transferor thereafter. The trustees of a business trust may be compelled to recognize and enter on their books a transfer of shares made in accordance with the trust instrument. Upon the presentation of a certificate endorsed in blank with the genuine signature of the owner, the trust is under duty to transfer the shares and issue a new certificate on demand, and it is not negligent in doing so. In so doing, in the absence of fraud or collusion or notice or lack of title in the persons presenting the fund. But this is only because you, the grantor, allowed this. For me, I require a little bit more evidence. Like, say for some reason it got sold off and traded. Like, we're dealing now with a lot of what we're calling fraud and misrepresentation of who are the owners of shares of our mortgages and shit like that. Okay, well, I need a little bit more. Before I change my books, I need more that you are now the owner of it and how you are the owner. That's how I would write into my stuff. A court of equity has jurisdiction to compel the trustees to effectuate such a transfer in accordance with the provisions of the trust. But if it's written down, it got to be done. It all depends on what additional bylaws you add for requirements for proof of ownership type thing, or proof of beneficial interest, right? Compel the trustees to effectuate such a transfer in accordance with the provisions of the trust instrument, but the burden is not an alleged transferee to show that he is entitled to have the transfer perfected. Like, one requirement too for a business trust that I would do is that you have to be notified, right? Even though up here they say that it's not wrong if you didn't get notice. But the thing is, if you put the requirement of notice, then you should get notice, and it should be upheld in law, unless there's some statutory prohibition against that shit, right? But I doubt it, right? This right here, this court case is probably because he didn't do it. The grantor didn't write it down that he wanted to be noticed when there was a sale of one of those shares. Because if you think about it, right, you got, let's say you make 1,000 shares, 10,000 shares, right? Do you think 1, 2, 3 people are going to get all those shares? Now you have to think about business-wise that you're not going to know these people personally. The only thing that you're doing is keeping a track record of who is the owners of them. You know what I'm saying? You're keeping a record for that, and you want to be given notice of any change of that record. That's it. Now, whether they're allowed to sell it or not will depend on their fundamental right, if they could or not, without you being allowed to buy it back or anything like that, to be stopped. A court of equity has jurisdiction to compel the trustees, blah, blah, blah. It has been held that a brokerage firm regularly dealing in shares of a business trust may maintain an action to compel the trustees to make transfers in accordance with the trust instrument. And the fact that a purchase of shares was made by a corporation as agent for another person does not relieve the trustees of their duty to recognize the record to recognize and record the transfer where the offer was made in good faith and met with all the requirements of the declaration of trust. However, a court will not compel the trustees of a trust to transfer shares obtained through a breach of faith and the use of confidential information secured through the former employment of purchasers of the trust. This supplement with footnotes. A provision of a trust instrument requiring a notation of a transfer of shares on the books of the trust and the issuance of new shares does not apply to the pledge of such shares. The court stating that neither law nor custom require the issuance of a new certificate upon a mere pledge. Pledge, the pledge deals with that specific property. It doesn't create a new certificate. That piece of paper that's being used as a pledge is the thing. Without it, it's not a pledge no more. You can't make another certificate based on a pledge, a copy of it or whatever. That's why I always look at it. How I would look at it. This is the case I'm going to read. So, trust instrument provisions to the effect that possession of a certificate shall not vest ownership of the shares represented thereby in any person other than the one in whose name the certificate is issued. So this is you making definite beneficiaries. As between the trustees and such holder, until the transfer is duly made on the books of the trustees, will not relieve the trustees from liability for wrongfully paying dividends to a previous owner of the stock after they become into knowledge of the transfer. Where the trust instrument provides for the transfer of shares on the books of the trust, the trustees, although given absolute and sole supervision of the affairs of the trust, have no right to control the sale of shares and no power to refuse to transfer them on the books of the trust, where the holder complies with the requirements of the trust instrument. It's the law. It's your law. Holding also that when a certificate is presented for cancellation for the purpose of having a new certificate issued, and the certificate bears the signature of the owner thereof in blank by way of assignment, the only duty the trust owes to the owner is to verify his signature and to ascertain his genuineness. So look at that's pertaining to like just to make sure that it's him. That's the only duty in the trust instrument that was given to the trustees to find out that the reasons why the remake of this instrument is a valid one. Holding that the court will not grant any relief tending to aid such purchasers in a business based upon their breach of an undertaking not to engage in a business competing with that of the trust, which is a given. This is self-dealing. Don't do no self-dealing as a trustee. Section 29, bequest or inheritance. Shares in a Massachusetts or business trust may be bequeathed by the shareholder, and upon the death of the shareholder, intestate, meaning given up by will. His or granted, delivered, whatever, transferred over by will, by gift or whatever. His personal representative becomes vested with the right of the shares and the undivided profits. Under a statute providing for an accounting in the local probate court in the administration on the estate of a non-resident with respect to his estate found here, ancillary executors of a deceased shareholder have been held to be accountable for shares in the Massachusetts Trust in the state in which the shares were kept. The trustees resided, the home office of the business was located, and in which certificates must be transferred and new certificates issued. Although the testator was domiciled in another state, for this purpose, there is said to be no difference between such a certificate and a certificate of shares in a domestic corporation, and that's because it deals with something else, with wills, and I know it has to do with wills and inheritance laws and so forth. Let me see if they got the case here. Nah, I don't know this case. But here, I would read this case for sure. Rights of heirs to accounting, right? Footnote number 3. All three of these. All two of them. Right? Shares in the Massachusetts or business trust may be bequeathed by the shareholder. That's footnote 2, actually. Right? And upon the death of a shareholder intestate. Right? But this is assuming that in the state that you created this trust, there's no law, or there is protections that where you can't stop this from happening. If there's a choice for me, if there's a choice, right, I would limit where it gets transferred to, right? Like if I had created an estate that I want to maintain it within that state, right? I would do it to where by will only gets passed on to a bloodline, his children and so forth, or grandchildren and so forth. And if there's neither one present, then it will be to a brother or sister or something like that. I would keep it in the family, not to where it could be given to wherever. It's a restriction on your beneficiary for sure, but it stops from outsiders coming in. And same thing here. You gifted and stuff, that's the same thing. You choose, but it's to the extent that you're not violating the beneficiary's fundamental right in the state that he's in. And that's what protects them from you being able to do that and restrict them from trading it, selling it, borrowing, whatever, assigning it. All right, so that was it for part 4. The next section that I'll be reading is shareholders, members, or sesquicu trusted, which is all the same thing, beneficiaries, right? Members probably more describe of people who bought into them, bought the shares and stuff. But yeah, but this will deal with the rights. Where up here was all about the shares, the transfer of the property itself, and dealing with that type of property. That's not property dealing with the trust res. That's property in terms of shares, intangible rights and stuff like that. All right, so hope you guys enjoyed, and I'll see you guys on the next one. Have a good night, and happy holidays.